Without further delay, I'll pass to, I'll thank again Professor Whish and pass the word to him.
Well, thank you very much, Bruno, and hello, everybody. Nice to be with you again. So yes, hopefully you have got my handout in front of you. And last week I got to the foot of page 6. I was talking about the horizontal agreement cases under Article 101. I am talking about 102 today, just to make the point. The foot of page 6, 7, 8, there's a few notes about some vertical cases that the Commission has been and is doing. Nothing of particularly big interest there. I say that because they are, most of them are very specific EU cases. You know, the EU has an obsession, if you like, a sensible obsession with single market integration. And it doesn't like vertical agreements that attempt to segment one member state's territory from another. And so when you get agreements containing territorial restrictions in the form of prohibitions on active and passive selling from one member state to another, or, for example, on page 8, tour operators, agreements between tour operators and hotel groups that result in rooms in hotels being sold at different prices according to the country of origin of the holidaymaker, sort of geographical discrimination based on your residence. These kind of things violate the single market principle, and the Commission dislikes them intensely, and there's a 60-year history of action being taken against them, and those cases are still happening, in particular in circumstances where the territorial restrictions are imposed online through platforms and platform selling rather than in the old physical bricks and mortar environment. So I just draw your attention to the fact that those cases are there, but I wasn't proposing to talk about them now because, as I say, it's very much an EU kind of issue. So let's enter the world of Article 102, abuse of dominance. And abuse of dominance is always immensely interesting. It's controversial. It's easy to see why competition authorities don't like, to use the words of Article 101, they don't like agreements to restrict competition. I mean, if we believe in competition, if we believe in competition law, it's pretty obvious that an agreement to restrict competition is something that authorities aren't going to like. We can debate what is a restriction of competition, but it's obvious that an agreement to restrict competition is going to be viewed with disfavour. But then you come to abuse of dominance, and you are entering a very different world, because here we are allowing a competition authority to look at the unilateral behaviour of a firm and say, we don't like what you're doing. We think you're bullying and it's abusive, and here is an enormous fine. So you're second guessing the unilateral decisions of dominant firms. I'll call them domcos. And of course it's controversial. And of course the dominant firm is going to say, well, what we're doing is we're just improving efficiency and we're producing better products and it's good for consumers. And the competition authority says, yes, but it's foreclosing access to the market. These are difficult issues. What is interesting at the moment, in particular because of the rise of the platforms, is that we're having a great upsurge in cases. The European Commission in the last 3-4 years has adopted about 10 abuse of dominance decisions, imposing fines in excess of 10 billion euros. In the preceding 10 years, they hadn't adopted 10 decisions. So there's an enormous uptick of activity. And of course, the cases, they're tending to get bigger and the fines are getting bigger, and the defendants are bigger, and they are typically the platforms. So there's a lot of very interesting stuff here. So let me go through it. It's interesting just to point out that my handout in the last 12 months doesn't actually have a commission decision. And that's because the most recent decisions were 2018-19. They've dropped out of my handout, but they've now moved on to the General Court. So if I'm giving this lecture this time next year, I would anticipate that there will be several really major judgments of the General Court, but we're just in that sort of quiet period between the decision and the court judgments. But there's still plenty for me to talk about. So let's look at the list on page 9. These are current investigations. And the first two I won't say anything about. The first one is about rail transport in the Czech Republic. Apparently it's an allegation, I think, of predatory pricing. The case has been around for a long time. Let's wait and see what happens there. The next one is something to do with the electricity sector in Greece. I don't honestly know anything about that one, so we'll pass over that. But then we get to Aspen Pharma. Now, this is where it gets interesting. So this is a case in which a pharmaceutical company, Aspen, of South Africa, produces a number of anti-cancer medicines. These are in the area of leukemia and similar blood-related diseases. And Aspen is supplying these drugs, which incidentally came off patent 50 years ago. So we're not talking about some fantastic new drug where recently there's been vast amounts of research and expenditure and risk and so on. This is a very, very old series of drugs off patent. And what happened is that several years ago, the Italian Competition Authority, the AGCM, had a look at this and said, we consider that Aspen has been increasing the prices of these drugs by an outrageous amount, so much that we think that the prices that are now being charged are abusive and contrary to Article 102. And so the Italian authority, I would think it must be 4 or 5 years ago, decided to fine Aspen. That case, incidentally, has now been all the way through the Italian appeal court system. And earlier this year, the Consiglio di Stato, which is the top court of appeal in Italy, has upheld the finding of excessive, abusive prices. So in this particular case, the European Commission then says, well, actually, Aspen operates across the EU. And it's also charging these kind of prices in Lithuania and Germany and the UK and so on and so forth. And so the European Commission decided that it would open an investigation into these allegedly excessive, abusive prices. Now, it looks as though we're near the end of this case, and I'll explain that in a moment. But let's just say a little bit more about it. Why is the case so interesting? Why has it provoked so much controversy? And the answer to that is that it is almost unheard of for the European Commission to examine and investigate prices simply on the basis that they are excessively high. There's no doubt that excessively high prices can be an abuse, because Article 102.2a of the treaty says so. The first example it gives of abusive behaviour is the imposition of unfair selling prices. So the people writing the Treaty of Rome back in the early 1950s, they certainly envisaged that, if you like, price gouging by a domco could be abusive. But in reality, when it's come to it, the Commission hardly ever does these cases. Why not? Well, there are very good policy reasons for competition authorities not investigating high prices. Because if you really have got, as it were, the cartoon model of a monopolist that has so much market power that it can charge monopoly prices, then the sensible question for a competition authority to ask is, how can they do that? Because surely, at least in the medium to long term, any market in which excessive prices are being charged will eventually auto-correct, because somebody will be incentivized to enter the market and try to bring the prices down. So the sensible use of a competition authority's resources would be to ask, how can they do that? Is it because Domco is indulging in anti-competitive exclusionary behavior? Well, if so, let's address that behavior. Or alternatively, as can very often be the case, is it because there are government restrictions or licensing provisions which are inhibiting the emergence of new competition? Well, in that case, let's be a competition advocate and say to the government or say to some regulatory body, don't you realize you are harming competition? Now, overwhelmingly, that is what competition authorities tend to do. But one of the many maxims of competition law that I have taught myself over the years is never say never. And you might come across a case where you can't identify anti-competitive practices, and maybe it isn't explicitly government's fault, and yet prices are being charged that really do seem to be harmful. I mean, if it's a drug for the treatment of leukemia, the patient isn't in a position to influence what's going on. Actually, ultimately, it's going to be governments and taxpayers probably who are picking up the bill. And in those circumstances, the competition authority can, as it were, act on behalf of the government in the interests of the population more generally. So there are lots of very vexed and interesting policy questions here, but sometimes a competition authority does feel that it needs to intervene. Now, separately from this case, and I don't know what the position has been in Brazil, but several member states have also been looking into the practices of these pharmaceutical companies. And in the United Kingdom, our Competition and Markets Authority took a case against Pfizer, well-known drug company producing a drug called phenytoin. And our CMA came to the conclusion that it was guilty of excessive pricing and imposed a fine on it of £90 million. And that case went to the Competition Appeal Tribunal, which actually annulled the decision on legal grounds, but remitted the investigation back to the CMA for further analysis. In the meantime, the CMA appealed to our Court of Appeal, which handed down a judgment in, I think it was April of this year. And it's a totally fascinating judgment on what constitutes excessive, abusive pricing. So that case is called Pfizer and Flynn against the CMA. If anyone's interested, I've got it over there. I can give you the reference later on when we come to questions. But there is a very difficult question of what the legal test of excessive pricing should be, and I can talk about it later if people are interested. Suffice it to say that case is now back with the CMA for further consideration. The European Commission entered an amicus curiae brief before the Court of Appeal to give its opinion, and now we've had the judgment. Anyway, that now brings me to the likely outcome of Aspen. Now, if you go back to my handout, you'll see that I say commitments to reduce price market tested 14th of July. And the point here is that in European competition law, we have the possibility of the Commission adopting an Article 7 infringement decision, but that's Article 7 of Regulation 1 of 2003. But we also have Article 9 of Regulation 1 2003, whereby a firm or firms under investigation can make offers to the Commission, commitments that they will change their behaviour, and the commitments they give will be legally binding, and an infringement of them can lead to very serious consequences. But if the Commission decides to accept the commitments, then the case is closed. There is no finding of infringement. Equally, there is no finding of no infringement, but the case is closed, the commitments are given, and that's the end of the matter. So what has happened here is that on the 14th of July, the Commission announces that it has received commitments from Aspen, and the commitments are, firstly, that it will reduce its prices for these 6 cancer medicines by, on average, 73%. Aspen will commit to that price cap, the price caps, for a period of 10 years. And Aspen also commits that it will go on supplying the medicines in question for 5 years. And after 5 years, if it ceases production, it will ensure that its market authorizations are assigned to somebody else who will take over production. So that's where we've got to. And I have not heard what happened next. I mean, that's the 14th of July, August, September. Normally the consultation period is 2 months. Also, normally the Commission closes down for August because the sun is very nice in the south of France in August. But of course, this year is a little bit different. We'll wait and see. But my hunch would be that before Christmas, this case will be closed. And it'll be very interesting because, you know, you have to have a wash up after these things and ask yourself, was this good or was this bad? Was it necessary to do the case? Well, probably I would say yes, because there should have been a regulatory system in place to prevent the pharmaco doing this kind of thing. So I can see why competition law action may need to have been taken. But if you get a commitment decision, it means you don't actually get a formal finding as to the law, because the decision will not be a finding of an infringement, nor will it be a finding of non-infringement. It'll be a correction of Aspen's prices, but we won't know anything more about the law of excessive abusing pricing. So I suppose from my point of view as the professor who likes to know the law, I'm kind of mildly frustrated because I'd like to see an infringement decision and an appeal, and then ultimately you get an authoritative judgment from the Court of Justice, and then that is a public good that all of us stakeholders can make use of. On the other hand, I entirely understand pragmatically why a competition authority would be attracted by this kind of approach. And at the very least, it sends a signal to all other pharmaceutical companies. We are interested in these cases, and we do have the right to come after you if we don't like your prices. So, I mean, at many, many different levels, it's a very interesting case. And as I say, it is one of several others, including Pfizer and Flynn in the UK. The CMA has 2 other cases on excessive pricing. I suppose the last thing I would say about it is, of course, that in the US, this would not be an antitrust case, because Section 2 of the Sherman Act is about monopolization and attempts to monopolize. Section 2 does not apply to exploitative abuses on the part of a dominant firm. That's a very significant difference between the EU and the US system. So I think that's all I'll say on that for now. I can see that questions are coming into the chat box, but I do think it's better for me on this occasion to give my lecture, and then we can have plenty of time to go back to them, and Bruno can be reading them and kind of curating them into some kind of sensible order for when I answer questions. So that's that one. Qatar Petroleum, I've got nothing to say about that. Amazon, well, this is interesting because obviously at the moment there is this intense interest in the digital platforms and the power that they may have and the propensity that they may have to act abusively. And in my handout, I got Amazon and I've got Apple, and over the page, Google get a mention, and I am going to tell you something about the Facebook case in Germany in due course, even though it's not actually in my handout. So of GAFA, we've got all of the GAFAs in this presentation today. Now, what can we say about these platforms? I mean, the first thing we have to say is that there are lots of different platforms, and platforms do different things, and they're not all the same by any manner of means. So when you hear some politicians saying, we need to regulate platforms, I mean, it's kind of stupid, because what you need to be doing is to say, what theories of harm can we identify, and which platforms are capable of producing which kind of harm, and then you address these things in a sensible and systematic way. And it may well be that some things are better dealt with through ex ante regulation, and it may be that some things are a matter of privacy or B2B unfair terms or whatever. So we've got to concentrate on the things that truly might be antitrust concerns. But one of the concerns is, if you want to call it this, self-preferencing, when you're in a position that your position in a very important and powerful platform enables you to do something that makes it possible to leverage yourself, to spread yourself into neighboring markets. Neighboring is a nice expression rather than horizontally related or vertically related, because these geometric shapes don't always work. It's just the idea that here am I on a platform, and there are all sorts of peripheral other things that can be done on that platform, and I might be in a position to boost my position there as a result of my gatekeeper role, if you want to call it that. Anyway, Amazon, I mean, the Amazon story is fascinating, isn't it? Because it started out life, I don't know when it was, selling books online. That's what it was, and the Kindle, and gosh, wasn't it revolutionary? And then over time, you begin to realize it's not so much the book, it's the platform that is powerful. And then you realize that you can build platforms that can sell other things, and other people can sell other things on that platform. And so you get to the position where, for I don't know how prevalent they are in Brazil, but you have the sense in this country that life would have come to an entire halt had it not been for platform. And as far as I can see, my partner must have shares in Amazon, because they appear to visit about 9 times a day, it seems to me. So obviously a remarkable, dare one say, essential facility they appear to have become. But then the problem in this case, which is all pre-pandemic, is that there is the Amazon platform, and huge numbers of sellers, retailers, distributors are selling through the Amazon platform, whether it's ink cartridges or greenhouses or bicycles or anything you can name are being sold through the Amazon marketplace. And Amazon is itself a retailer. Amazon itself has brands that it sells. And then because it has this formidable range of contacts with other commercial operators on the market, through those agreements that it has entered into, it is able to derive vast amounts of data about greenhouse sales and which kind of greenhouses appear to be popular, or who is buying which bikes. And if there's a new generation of electric bikes, which ones seem to be the most successful, and what kind of prices do people seem to be willing to pay for them? And is there a part of the country where electric bikes are sold more than in another part, because one part over here is flat, you don't need an electric bike, but over there it's more hilly. And so Amazon, through its position as a marketplace, is able to mine this data and then use it for its own retailing activities, knowing exactly what products, where to target them, the demographic, the price, and so on. And so the argument, in essence, is that over a period of time, through all these relationships that Amazon has over here, it will gradually eliminate them from the marketplace, because we, the public, will inevitably or may well transfer to its own brands. Now, that's the essence of the case. And of course, Amazon will say that this is complete and absolute nonsense. And I don't know the merits. I don't know the details of it. But that is the kind of argument that is being run in the Amazon case. Let's wait and see. Note, of course, that other authorities are looking at Amazon, FTC, Washington, the Italians, the Luxembourgers. In France, the authority was looking at the terms of the agreements between Amazon Marketplace and its customers, the people selling through it. And the French authority was concerned that the terms of the contracts were oppressive, that they indicated or reflected a significant imbalance of bargaining power between the parties. Let's never forget that domestic systems of law may have quite separate provisions, nothing to do with antitrust, on unfair contract terms, on unfair business practices in a B2B sense, not a B2C sense. And the French authority sent that case off to the relevant ministry that enforces those kind of cases, which took Amazon to court, and a fine was imposed because of the terms, not because of an antitrust infringement. Now, the next case is different, and I mention it for a quite different reason, which is that in the EU system, you have these cases on possible abuse of dominance. And of course, abuse of dominance cases are complicated. There's no question about that. You can't do a simple abuse of dominance case. You can do a simple horizontal price fixing case. I mean, sometimes it just is utterly obvious. The only question is how much to fine. But no abuse of dominance case will ever be simple, market definition, dominance, blah, 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 blah. And so cases typically take, I'm just wondering what to say. I mean, certainly cases can take 3-4 years. There have been cases in history that were 5, 6, 7 years. And so a question arises, when is it suitable for a competition authority to use its power to impose interim measures? To say to Domco, look, we think your prices are predatory, or we think that your rebates are abusive, so don't apply them until the investigation has come to an end. Interim measures. Now, the Commission does have a power to impose interim measures, and it's contained in Article 8 of Regulation 1 of 2003. Which came into force in May of 2004. So that instrument has existed for 16 years, and until Broadcom, the Commission had never used it. Under the previous legal regime, they had adopted interim measures in a case called IMS Health in 2001. IMS Health appealed. The General Court annulled the interim measures, and the Commission after that has never used the tool again. And part of the thinking was, if we adopt interim measures and then there's an appeal against the interim measures, then we have to throw loads of resources into the appeal against the interim measures. Wouldn't it be better actually to use those resources just to get on with the case? And so the instrument fell into disuse entirely. And then a lot of people started questioning that and saying, oh, come on, Commission. I mean, especially in some of these platform type market cases, you have the phenomenon, and it is a phenomenon that exists, of tipping, that eventually everyone might tip in favor of a particular platform or a particular standard or whatever it might be. Now, that may happen as a result of abusive behavior, but what's the point of deciding 3 years after the market is tipped that this was attributable to abuse? Because the market has tipped and you're never going to be able to reverse that. So query, what about this interim measures tool? And it's interesting because lots of people were arguing that. And then in, October of last year, the Commission adopts interim measures for the first time in 18 years. Not, let me add, in a platform case, not particularly in a tipping market, but nevertheless it did adopt interim measures. And in a sense, as interim measures cases go, it's a relatively simple one, in that Broadcom is supplying a certain type of chip to big OEMs, and the Commission objects to a couple of clauses in the agreements, one of which is tantamount to exclusivity, imposed, it would say, by DOMCO, and the other is a kind of a bundling clause. So here the Commission is identifying contractual clauses that it thinks are abusive. Well, one of the things I would say is, if you're going to adopt interim measures, the measure needs to be quite a simple measure. And who knows whether the terms are abusive, but it's certainly quite a simple measure to say, don't enforce clause 4.2b(1) until the investigation is over. So as an interim measures case, it has that virtue of simplicity, and that's exactly what the case is about. Contractual exclusivity, contractual bundling. Now, there may be objective justifications for the practice. In the end, there may be no abuse, but it's quite an easy case for interim measures. So the Commission imposed them, and Broadcom has now appealed the interim measures to the General Court. Now, I welcome that, because our law says that you can have interim measures where there's exceptional urgency, or some expression to that effect, where there's urgency because of a serious harm to competition. Well, those are kind of the words that need to be tested on appeal. How urgent is urgent? What is a serious harm to competition? And no court has said anything about that in the EU system for 18 years. So it would be a welcome judgment to have, just to kind of find out what is the court's attitude to interim measures. Does it think it's an important instrument? Is it going to be relatively benign to the Commission? Now, I'm pretty sure the Commission used the tool on this occasion, because it's almost as though you've got a box up on the top of your wardrobe that contains something interesting, and you get it down, and the first thing is you have to dust it off, and then you look inside to see what's there, and is it still usable? Well, I think what the Commission has done here is to say, let's do an interim measures case. Let's see what happens on appeal. And if it goes well, who knows? We might use it in future in more problematic and difficult cases, including perhaps tipping markets. But one would have to say that, you know, if the abuse is that we think that Google has designed its search engine in such a way that it relegates comparison shopping tools to page 4, it's very difficult to know what the interim measure would be in a case like that, is the interim measure to redesign your search tool? I mean, what could the interim measure be? I don't know. I haven't got any answers to my own question, but I hope you understand my point that some cases are more suitable for interim relief than others. What has now happened in this case is that Broadcom has offered commitments to settle the substantive case. And those commitments went out for market testing in April, and there are big players in this market, so I'm sure the Commission will have had lots of reactions. So we will wait to see what actually comes of that. My kind of hunch is that probably this case is heading for the commitments procedure. What I don't know is, if the Commission accepts commitments, will Broadcom nevertheless continue with its appeal against the interim measures? Because on the one hand, if they've changed their commercial behaviour, as it were, what's the point of fighting the interim measures? On the other hand, they, certainly I, would be interested to see what does the court have to say about interim measures in the modern antitrust world. So I just don't know what the answer to that is going to be. Watch this space. Okay, so that's Broadcom. Oh, I should just say, incidentally, that in the EU, competition authorities have been using interim measures more recently than ever in the past. And I don't know whether any of you subscribe to PAR, their competition service, but PAR on the 27th of April produced what they call PAR Analytics, whereby they have formidable data. I mean, they monitor every member state on a daily basis for everything that's happening in the world of competition law. And they've looked back over a 5-year period across the 28 member states of the EU, now 27, to find out which authorities have adopted interim measures when and how often. And it goes year by year, and suffice it to say, the big green bar is 2019, and the small 2020 bar, that was as of April of this year. So it tells you a clear pattern. The authorities are using this tool more than they did, including the French authority, I've just looked at it here, fairly recently against Google. Okay, so that's Broadcom. Then we move on to Apple. 2 investigations opened into Apple. And of course, Apple is, when we talk about platforms, it's easy to understand what we mean by the Google, Amazon, and Facebook platforms. Apple is more kind of an ecosystem where we have our wonderful phone, but then the phone is linked to all sorts of other things. And so the Commission has launched 2 different investigations. The first is into Apple Pay. So, of course, one can go into the supermarket and then you just touch this on the terminal and that's it. All you have to do, and it's through the technology that is Apple Pay. And the Commission says we are concerned about the way that Apple Pay works in the phone, because as I understand it, that phone, in terms of this kind of technology, the touch-as-you-go technology, the iPhone will only take Apple Pay. No competitor to Apple Pay can have access to that phone. It's all to do with what's called the near-field communication technology when you're in the shop or the restaurant or whatever it might be. Also, the Commission says it doesn't like the terms and conditions on which people can make use of Apple Pay, and they say that there are alleged refusals of access, presumably arguing that this is an essential facility of some kind. So that's one Apple investigation. And then the other one is the way the App Store works. So, of course, on here I have my App Store, and I might decide that I want to, through the App Store, I might want to find Spotify, because I've heard that Spotify has a fantastic catalogue, and that's the place to source the streaming of music. So I go into App Store, I find Spotify, I decide I'm going to subscribe, and then the way the system works is the annual subscription is 100, and because I'm purchasing it through App Store, Apple takes a 30% cut, and there's no way around that. So Apple will take 30% in circumstances where Apple has its own music streaming service, and I, the consumer, will be able to work out that if I source my streaming from Apple rather than Spotify, because of the way the pricing system works, the Apple music is going to be cheaper. So it's a sort of a self-preferencing theory of harm. So that's what's being looked at there. Separately, it seems that also Spotify is not allowed, if I am in communication with Spotify via the App Store, Spotify is not allowed to tell me there are other ways of accessing our market other than through the App Store. And Spotify is prohibited from doing so. So that's what's going on there. Then over the page, we've got, I mentioned that there is an investigation of Google in relation to job search. Now, the reason that it's not in my formal list is that, as far as I'm aware, the Commission has not formally initiated proceedings yet. In all the cases on page 9, it has formally opened an investigation. The Google case, it is still investigating. But the way this one goes is that I'm looking for a new job. And we all start out with a Google search. And so I'm looking for a job. I've decided I'm bored with the complexity of intellectual property, of competition law. So I now want a job stacking shelves in supermarkets. So I'm looking for an attractive shelf stacking job in a supermarket. And what happens is Google job search comes up. Well, there are lots of other job search websites, and they say we never appear on page 1. So we are being relegated, and thereby we've effectively got no access to the eyeballs of the people that we're trying to do business with. Well, so that's what's being investigated. But what is interesting about it, of course, is that not essentially, I mean, maybe I've got this wrong, but is that not essentially Google shopping? Because the Google shopping complaint was that I want to buy something, what comes up? Google shopping. And that's how I buy my greenhouse. But there may be other shopping tools that actually would be much better in terms of information about shops and so on, greenhouses and so on and so forth. But those searches only, those shopping tools only appear on page 4 of the search results. And then Google, the Commission in that case, did its research, and basically the research showed that no human being in the history of the world had ever reached page 4 of any search ever done by anyone. So that effectively, if the results are on page 4, that's the end of it. Now, the reason I mention that is that it's very interesting because one can see how this works to the disadvantage of the competitive, the competing job search engines. On the other hand, you can see why Google is entitled to say, it's our search engine and we can design it however we wish. Who are you to start telling us that we've got to design the search engine in a different way? Come on, surely this is intrusion gone mad. And the intriguing thing about that Google case is that if you think about it, if you think of the Commission's conclusion, of course, as you know, they were fined 2.42 billion euros there, and that case is now on appeal to the General Court. If you work from the conclusion backwards, the conclusion means, presumably, that there is a right, at least for some of those shopping tools, to appear on page 1. Because if the complaint is Google Shopping's on page 1 and everyone else is on page 4, that's another way of saying at least some of those shopping tools should be on page 1. Probably they can't all be, but some of them could be. But if you're saying that there's a right to be on page 1, isn't that effectively saying that page 1 is an essential facility? And that Google therefore has an obligation to carry competing search engines on page 1. Isn't that effectively what the Commission is saying? And I remember the day that the decision came out, getting numerous emails and WhatsApps from friends in the global competition village saying, Richard, does this mean that the Commission says that this is an essential facility case? Because if it's not an essential facility case, how can there be an obligation to carry competing tools on page 1? Well, suffice it to say there that the Commission clearly did not run Google Shopping as an essential facility case. Rather, it said that there's some sort of leveraging stroke discrimination practice going on here, whereby you're dominant in general search and then you configure the search engine in such a way that you relegate competing search tools but advantage your own search tool, thereby eventually annexing the neighbouring shopping market. And Google specifically argued in its defence in Google Shopping that the Commission failed to apply the criteria of the Essential Facilities Doctrine, the Oscar Bronner rules. And the Commission explicitly says in its decision, we weren't applying Oscar Bronner, so that's why we didn't look into essentiality and all the rest of it. Now, that is on appeal to the General Court. And one of the arguments is that the Commission should have applied Essential Facilities Doctrine, and it failed to do so. Now, I mention all of that because this is not on your handout, but I'm going to tell you about it, and it's an Advocate General opinion of the 9th of September, and it's in a case called Deutsche Telekom and Slovak Telekom against the Commission. If you want the numbers, C15219 and C16519. It's 2 appeals. Every case has its own docket number. So it's Deutsche Telekom C15219, Slovak Telekom C16519. And exactly the same point is being argued here. Now, this case is telecoms. And we've had so many of these cases in Europe: France Telecom, Deutsche Telekom, Telefonica, Telia Sonera, Polish Telecom, and Slovak Telecom. And you have the vertically integrated telco. It is dominant in the upstream local loop, the network. Downstream, it offers residential broadband services. So it's vertically integrated. There are other people at this level of the market that want to offer broadband, but they have to have access to the upstream network. Now, there's normally a regulatory obligation to provide access. So it is not that Slovak Telecom or Deutsche Telekom or France Telecom, they don't refuse to deal, but you can deal in a very curmudgeonly way. You can be inefficient in responding to questions. You can withhold technical interface information that is necessary to interconnect. You can impose terms and conditions that are onerous and unreasonable. You can charge a price that's discriminatory or unfair in some sense. So the Commission does not run this case as refusal to deal, but it does run it as a kind of a series of different kinds of abuses, unfair terms and conditions, unfair prices, withholding of technical interface information. And it says all of these are abuses. And then Slovak Telecom appeals. They did it. Deutsche Telekom is involved because it's the parent of Slovak Telecom. But Slovak Telecom appeals and basically says, first of all, in the General Court, what I've got here is an appeal from the General Court to the Court of Justice. But in the General Court, Slovak Telecom says, look, the Commission says that we're guilty of all these abuses, and we don't think we are. And if the Commission doesn't like the terms and conditions on which we deal, well, okay, we'll just stop dealing. We won't deal with these people at all. What could the Commission do about that? And then they say, logically, the only thing that the Commission can do then is to say it's an essential facilities case and that the refusal to deal is an abuse. But the logic of their argument goes that if it's not an essential facility case, then they are entitled not to deal. And if they're entitled not to deal, then the terms on which it does deal can't be abusive. Because if you don't like what we're doing, we will stop dealing. It's a logical argument. And of course, it is an argument designed to make it harder for the competition authority to bring a case, because the Oscar Bronner essential facilities doctrine is very difficult to satisfy. Now, suffice it to say, the General Court said, no, you're wrong, Slovak Telecom. There's an abuse of refusal to deal. That's Oscar Bronner. But there are all these other abuses as well. And they're self-standing. They're not interrelated. You can perfectly well have abusive terms and conditions without having to prove a duty to deal. And so Slovak Telecom have taken that fight on to the Court of Justice. And what I've got here is the Advocate General giving his opinion. Is he on the side of the Commission or is he on the side of Slovak Telecom? The answer is he is emphatically on the side of the Commission. He utterly rejects the argument of Slovak Telecom, and I would urge you to look at paragraphs 88 to 91. So remember, they're basically saying these cases should be applied subject to the Oscar Bronner essential facility principles. And what he says, this is Saumensgaard, the Danish Advocate General. He says, to sum up, the court has never applied the conditions laid down in Bronner to abusive pricing practices. 89, a decision now to treat such practices as implicit refusals to deal would effectively reverse entire swathes of case law. The judgment in Bronner would become the rule rather than an individual case. Paragraph 91, it would, to my mind, be a serious mistake to go down that road. So he's extremely clear. We now await the Court of Justice. I personally would expect the Court of Justice to agree with him, but it's critical. It's critical to the Google shopping case. Obviously, it's critical to the Slovak Telecom case. It's also critical to a case in the Lithuanian rail sector, where somebody asked for access to a rail line and the owner of the railway line tore it up. But they said that this was discriminatory behavior that had no merits. But now the Lithuanian railway company says, if we tore up the railway line, what you must be saying is that we refused to deal. So you should have applied the Oscar Proner criteria. And there are a couple of other cases where the same thing is being argued. I think that these people will lose, but you can see what the DOMCOs are doing this for. They are trying to turn these cases into essential facilities cases. And what they will then do is to say, or what they have done, is to say, let's look at US law on essential facilities. And many of you have studied, you've done your master's degrees in the States rather than in Europe, and you'll know the Supreme Court judgment in Verizon and Trinco, which almost argued the essential facilities doctrine out of existence. It is almost impossible to say that a refusal to deal is abusive. So if these people in these cases can up the standard to essential facilities, and if they can then link it to the US, then it means there's an awful lot fewer abuses in this world than historically we have imagined. So I think it's all totally fascinating conceptually. And over the next 2 years, these cases will come through to judgment, and we will hopefully know a great deal more. On page 10, I mentioned paroxetine last week. I think I also said last week that this is the pharmaceutical case, the pay for delay agreements. There's a separate point in the judgment, which is that if a pharmaceutical company sees these generic companies trying to enter the market, and then each time a generic company comes along and either challenges the validity of the patent or threatens to challenge the validity of the patent, I enter into some kind of agreement with it. Last week was the pay for delay agreements. There is another company that threatened to litigate, and GlaxoSmithKline said, well, why don't we appoint you our distributor on very favourable terms? If we do that, you're not going to litigate, are you? No, we're not. And the CMA said, this pattern of behaviour of entering into agreements with each generic company as it threatens to enter the market to cause it to go away, that behaviour in itself is an abuse of a dominant position, a contract-oriented strategy to exclude potential competitors. Question for the Court of Justice, is there such a thing as a contract-oriented strategy of eliminating competitors? And the Court of Justice says, in principle, such a thing is possible. So it may well be, in this case, that Glaxo is fined not only for entering into the pay for delay agreements, but also separately for abusing its dominant position by systematically buying off each would-be generic entrant by entering into some kind of attractive agreement with it. And then before I stop, I just wanted to mention two member state abusive dominance cases, because they're so important. I can't quite resist. I haven't put them in the handout. If I start putting NCA decisions into this handout as well, I will go completely mad, because there are 27 NCAs. But firstly, you'll all know about it, the Facebook case in Germany. And so this is where the German Competition Authority, the BKA, looked at Facebook's behavior in Germany. This is a case on German competition law. The BKA did not apply Article 102. But the German equivalent, I think it's Section 18 of their Act, says you can't impose unfair terms and conditions, just like Article 102. And what happens is, you're a German user of Facebook, And when you sign up to use Facebook, you do agree that Facebook can make use of the data it obtains from your use of Facebook. So you have agreed to that. Whether you like it or not, you have done. But of course, Facebook also owns WhatsApp and Instagram. And people use these platforms for different ways and in different, with different people and so on, and to do different things. And the BKA says the user in Germany in no sense understood or meaningfully consented to Facebook using the aggregated Facebook, WhatsApp, and Instagram data, which of course it then monetizes by basically selling personalized advertising, because it means in the end Facebook knows more about me than I know about myself. And that's what advertisers want. He's a greenhouse person, this one. And then I get bombarded with additional information about air-conditioned greenhouses or whatever it might be. And so the BKA says the German user didn't consent to this, and this is abusive in an exploitative way. This is not a case on exclusionary abuse, it's exploitation. Aspen, the prices, exploitative. Pfizer and Flynn in the UK, exploitative prices. BKA, Facebook, exploitative terms and conditions. Because of course there is no price to the German user other than the German user has given, in inverted commas, its data to Facebook. That's the price, but you can't call that an unfair price. But you can call it an unfair term and condition. So the BKA says abuse, and then imposes measures on Facebook to no longer aggregate the data derived from the three silos. Rather, it says these must be silos, and you can't pool all the information. So therefore, I mean, it is interesting to think of it in these terms. They have imposed a kind of internal divestiture on Facebook. They haven't said divest Instagram or divest WhatsApp, but they have said silos. And then the interesting thing was that Facebook appealed Facebook appealed those measures, also the substantive decision, but appealed the measures to the Düsseldorf Appeal Court. And the Düsseldorf Appeal Court said, we don't like these measures at all. We can't see that Facebook is dominant. There's loads of social media. And we can't see anything unfair about any of this. And it's not having any kind of effect on competition. So we annul the measures. And then the BKA appeals to the Supreme Court, which on the 23rd of June handed down its judgment in the appeal against the annulment of the measures. And the Supreme Court says, my words, not its. We don't understand what the hell the Düsseldorf court is on about. Of course Facebook can be dominant. Of course these terms can be unfair. And indeed, we can see how they have a detrimental effect on competition, because who's going to get a look in personalized advertising when Facebook is put at such a massive advantage? So I've hardly ever seen such a stark disagreement between an appeal court and a higher court, in this case, the Supreme Court. So obviously it's an amazing day for the Bundeskartellamt. The substantive appeal goes on, but the original decision stands. So I think that's immensely interesting. And then lastly, I wanted to mention a case in France on the 9th of September in the pharmaceutical sector. So much of this world today is about digital markets and pharmaceuticals. But this is about an agreement. This is about behavior of Novartis and Roche. None of you can possibly not have heard of Novartis and Roche. And there are two drugs. One is called Lucentis, and one is called Avastin. And Lucentis is I'm simplifying, but I think this is reasonable enough for the purposes of this. Lucentis is a high-priced drug, and it's used for treating certain cancers, but it can also be used, it's used for eye disease problems, macular degeneration. It's also used for other purposes, but it's high-priced. There is another drug called Avastin that can be used for macular degeneration, and it's a much lower priced drug. And so medical practitioners realize that Lucentis is very expensive if it's used for my eye problem. Avastin is much cheaper. And so that's what people in the know do. Now, a couple of years ago, there was a case called Hoffmann-La-Roche and the Commission that went to the Court of Justice. And in that case, the Italian authority had said Novartis and Roche had entered into an agreement that insofar as there was information in the market that suggested that Avastin was unsafe when used for the treatment of eye disorders, let us suppress that information. On the other hand, if we find information that suggests that it's dangerous to prescribe Avastin, then we will release that to practitioners and the medical profession and the relevant journals. So the agreement is, as it were, to denigrate Avastin in order to redirect prescriptions to the higher priced Lucentis. The Italian case said that there was an agreement between the drug companies to do this. The question for the Court of Justice was, if such an agreement existed, could it be a restriction of competition by object? And the Court of Justice said yes. So that's 2 years ago in the Court of Justice. 9th of September in France, the autorité says, well, these two companies, they're doing exactly the same thing here. They're trying to mislead the medical profession so that Avastin is not prescribed and that Lucentis is. But then the interesting thing about the decision, which is why I'm dealing with it under Article 102, is that the French authority says it's very much the same as the behaviour in Italy, but we don't think it's because of an agreement, or we're not going to deal with it as an agreement. We are going to say this is a collective abuse of a collective dominant position, and we are going to impose fines of 444 million euros. Now, I have to say, when I read that, it was one of those kind of wow moments in competition law, because this thing, collective dominance, it has existed in EU law for 30 years. And there was a time in the 80s and 90s when the Commission used it. But in the last 20 years, it has almost evaporated into thin air. Of course, the law is still there, but it's not used. Collective dominance is relevant in merger analysis when you're asking whether there's coordinated effects. But there haven't been 102 cases on collective abuse, on collective dominance. And then, as it were, out of thin air, the French authority comes up with collective abuse of collective dominance and imposes the biggest fine in the history of the world in collective dominance cases. So I think it's an immensely interesting development. Not a development of the law necessarily, but development to start using it again. It can only have happened following discussion within the European competition network. So the Commission and the other 26 member states will be fully aware of this. We're talking Novartis and Roche, who will obviously fight this the whole way up. Cour d'appel, Cour de cassation. I could well see this eventually going to the Court of Justice under Article 267 as a reference. So hugely interesting. Watch this space. Okay, right. So that's what I wanted to say on 102. I will stop there, and I'm very happy to discuss, take questions, etc. So I'm going to hand back to Bruno for him to decide what's going to happen next.
Okay, thanks, Professor. I think we have 3 questions here, and I would say that whoever wants to raise questions directly, there is a mechanism here where you can raise your hand. So please do so. Then I'll pass the word to you. But I'll try to make the ones that are here, or at least the first one. And I think we have one from Daniel and one from Anabatia. They may want to ask directly. The first one relates to abusive of investigations related to the pharmaceutical excessive pricing you mentioned. We, as I wrote, we do have investigations going on in Brazil as well related to mostly pharmaceuticals on excessive pricing and other companies that are actually products manufactured for the fighting of the virus. And this is going on here. And then the question that was raised was whether there were other investigations in Europe that are not only related to the pharmaceutical companies based on excessive pricing complaints. And I think you've mentioned other investigations like that, right, Professor?
Yeah, so let's deal with Daniel's question first, because it's a really good one. So the question is, obviously, what is an excessive price? I mean, quite apart from whether it's sensible as a matter of policy to do excessive pricing cases, there's the separate question of, if you do an excessive price, is there a legal definition of an excessive price? Now, this is why the Pfizer and Flynn judgment of our Court of Appeal is so interesting. And I've actually got it. I realised it was on my desk all the time because I put it in the pile in advance. So how do you decide what is an excessive price? There is an old judgment of the Court of Justice, United Brands against the Commission, which laid down a test in which it said, to be excessive, you have to ask first, is the price excessive in relation to its cost? Secondly, if so, is that price unfair in itself or when compared to other products? So that was United Brands and the Commission in 1978. And it's always been treated almost as though it was a kind of statutory provision that somehow contained the answer to everything. But of course, it doesn't contain the answer to anything. And the first reason I say that is that if you're trying to work out whether a price is excessive, I mean, what a cop-out for a lawyer to say, but it all depends on the facts of the case. But then what I mean by that is, if I'm a copyright collecting society and I'm accused of charging an excessive price for in royalties for licensing music to you, well, how do you work out what excessive pricing is for music? Do you go to cost? Well, what is the cost? You know, George Michael may have thought up the tune when he was walking along the beach in Mykonos. So there's not a lot of cost there. So what the hell's cost got to do with it? On the other hand, if I have produced a new anti-COVID-19 drug, well, then you could actually say, well, how much have you spent in the last 6 months? And, you know, you could get information on that. But then if it's aspirin and the drug was produced 50 years ago, well, what cost are you looking at? Are you looking at the cost of 50 years ago, or are you looking at the cost of producing the drug now? I mean, producing the drug now might cost next to nothing. So, I mean, the first helpful but unhelpful thing to say is it must all depend on the facts of the case. And cost may have different significance depending on the type of product in question. So what else could you do? Well, you could say, are your prices higher than comparable products elsewhere? Well, that might make some sense, but then if I'm dominant, the whole point may be that there isn't a comparable product, so that doesn't get you very far. But then maybe you could say, well, this is music being played on radio and television stations and in bars in Lithuania, how much do they charge for the same music in Latvia? So you might be able to do a kind of a benchmark competition. Or you might say, well, none of that really works. Maybe we better look at the return on capital employed. Well, that might be helpful, but not if it's all to do with something 50 years old. Or then we might say, well, let's look at profitability. And you might decide that if somebody's making a profit of 450%, whereas other people in similar industries elsewhere are making a profit of 30%, well, maybe there's something fishy about this. So my answer to you, Daniel, is, of course, there is no one way of doing it, and it really does depend on the facts of the case, which is why I wanted to mention Pfizer and Flynn against the CMA. Okay, it's the CMA in the UK. Okay, we're now out of the EU. On the other hand, the Commission itself submitted an amicus curiae brief in this case, in which it agreed in large part with the CMA. Furthermore, the judgment is Sir Geoffrey Voss, Nicholas Green, and Stephen Richards, all of whom have been in private practice, superb competition lawyers. Many of you will have read Nick Green's books on competition law, and he was an eminent QC and now an eminent judge in the Court of Appeal. And the first judgment in Pfizer and Flynn is written by Nick Green, sorry, Lord Justice Green. I know him, but I must give him his proper title. And there's a wonderful, well, it's a fantastic judgment because he begins, so don't worry, I'm just getting the right paragraph. No. He begins by saying, well, what does the jurisprudence say on this? And he goes through United Brands, Ministère Public and Tournier, Skipper Chirola, Scandline, Sferiga. He goes through every judgment there has ever been on excessive pricing. And then he gets to paragraph 97 and he says, I would draw the following conclusions. Paragraph 97 of the judgment. I'll give you the reference in a minute. I would draw the following conclusions. The basic test for abuse is whether the price is unfair. A price which is excessive because it bears no reasonable relation to economic value is an example of such an unfair price. 3, there is no single method or way in which abuse might be established, and competition authorities have a margin of maneuver or appreciation in deciding which methodology to use and which evidence to rely on. Kajay, that's paragraph 97.3. You have a margin of maneuver or appreciation. 4, depending on the facts and circumstances of the case, a competition authority might therefore use one or more of the alternative economic tests which are available. There is, however, no rule of law requiring competition authorities to use more than one test or message. It goes on. There are 8 sub-paragraphs to paragraph 97. But, I mean, in a sense, it's kind of, oh my God, this is difficult, isn't it? But the answer is, this is difficult. How could it not be difficult? And there is a world of difference between saying, am I charging too much for last Christmas I gave you my heart? That must be different from the price of phenytoin or paroxetine. Okay? Oh, the reference to that case, 2020, EWCA, which means English and Welsh Court of Appeal, 2020 EWCA, CIV, CIV, meaning the Civil Division of the Court of Appeal, 339. 2020 EWCA CIV 339. If you put that in as your Google search, I'm pretty sure it'll come up straight away. So, I mean, that's my general answer to the question. then, Bruno, I can't actually see it. Didn't you say that there was a question about whether there are other cases on other products and their prices in Europe?
Yeah, if there were excessive pricing investigations not related to pharmaceutical companies.
I can't actually see that question, but leaving that to one side, yes, there are. Now, I do remember 2 years ago, the French authority looked into a case on, I think it was the disposal of medical waste, and came to the conclusion that I think it was a laboratory in France that was in a dominant position, was charging an excessive price for the disposal of medical waste. I seem to remember that was being used as a kind of a leveraging mechanism to get other people out of the market. There are certainly other pharmaceutical cases around. I'm trying to think of any other products. There are some, and I can't immediately remember what the other products are. What I would say is that there's been a kind of I know what I was going to say. I'll come to it in a moment. What I would say is there's been a sort of a resurgence of interest in excessive pricing. And then the thing I was going to say is that interest has been intensified by the pandemic, because right at the beginning, you suddenly had the phenomenon of visitors walking downstairs. You suddenly had the phenomenon of hand sanitizer, face masks, all sorts of things. And a question arose then, do competition authorities have the power to do anything about this? To which the answer is, in principle, obviously, yes, because depending on the applicable law, but excessive prices can be abusive. On the other hand, is competition law the right tool to deal with opportunistic price gouging? To which I think the answer is almost certainly no, because you've got to define a market and all that kind of stuff. And some people were price gouging that you could never considerably consider to be dominant. On the other hand, if I was an authority, I would at least remind people that the abuse of excessive pricing is there, because it might have the effect of causing reflection on behaviour. Also, of course, sometimes competition authorities have other powers, like control of misleading advertisements, because sometimes what was going on was not so much the gouging as the making absurd claims about products and using that as a way of affecting sales. But I would just say more specifically still there, do remember you can define a product market, a geographic market, but you can also define a temporal market. You may have a market that exists at a point in time, though in steady state it doesn't exist. And that goes back to a case in Europe called BP against the Commission in 1977, when after the OPEC oil crisis, when world oil prices were quadrupled, there was a problem of oil companies having to decide to ration and who they should supply. And I won't go into the case, but suffice it to say, the Commission identified a relevant temporal market, meaning the conditions of supply and demand at the period of crisis and shortage. And the Court of Justice accepted that it is possible to have a narrow market definition. So in COVID, you could have a narrow temporal market, and with supply of something like hand sanitizers at retail level, you could have a narrow geographic market, which might lead to the conclusion that a particular wholesaler or distributor was guilty of abuse. So that's that. Oh, I've just seen the question from Raphael Parisi. So I hope I've answered that. How do you do? What is your name? I can read Portuguese. My name is Richard. Okay, that's an answer to that question at 2:41. What else have we got here?
From Anabati, I think, is the next one.
Yeah, well, didn't I deal with that in the Slovak Telecom case? This question of, I've always been struck by this with abuse of dominance cases, or as a professor setting exams in questions where it's obvious that somebody up here is trying to eliminate someone down there, often in a neighbouring market downstream. And then Domco does this, that, and the other. What is the answer to the question? And it's quite often the case that you think to yourself, well, the pricing might be discriminatory. At upstream level, it might be excessive. If it's not excessive, it might be a margin squeeze. Could it be a constructive refusal to deal? Is it, in effect, a refusal to deal? It is possible. As a competition authority, you can ask yourself, how should we run this case? And it sometimes happens that a competition authority starts by running it as this type of abuse, and then maybe 3 months later or 6 months later, they say, actually, no, it'd be better to do it this way. And you do sometimes get supplementary statements of objections where DG Comp or the CMA reformulates its claim. But the point I was making about Slovak Telecom and Deutsche Telekom is that the Commission said, we're not doing these as essential facility cases because it's a very difficult doctrine to satisfy. But that's not to say that it mightn't have done it as an essential facility case, or different point, it might be that you say it's going to be very difficult to demonstrate essentiality, indispensability. On the other hand, the conduct is so obviously discriminatory, let's do it as discrimination. And that is what the Court of Justice is going to have to decide in Slovak Telecom, knowing full well that it's very important to the Google case and the Lithuanian railway case as well. Then I'm asked, do I have a personal opinion about the Facebook case? Well, I don't represent anyone other than myself. So I can say what I think about it. I'll start by saying that I think it's known that there are a lot of authorities, competition authorities, who consider that this should have been dealt with as a matter of privacy. And you've got a data privacy commissioner, and there's a regulation in Europe about it, and so shouldn't it be dealt with that way? And I think it is clear that the European Commission, DG Comp in Brussels, did not think that this was a suitable case for competition law. And I think they let that be known. And at one point, the commissioner said that she thought that this was really a privacy matter. I myself don't go along with that. I entirely accept that the same conduct might breach another system of law or laws. But the fact that there's a privacy issue doesn't, to my mind, preclude the possibility that there could also be abusive behaviour. And in this particular case, the Bundeskartellamt did talk both to the German Data Privacy Commissioner and to the Irish Data Privacy Commissioner, and both of them were content for the BKA to take the case. Why do I mention the Irish Data Privacy Commissioner? Because for these purposes, Google is domiciled in Ireland, and you're therefore subject to the jurisdiction of the Irish Commissioner, not to the German one. I myself am quite comfortable with the idea of it being dealt with under competition law, in the same way as you could have a case on possible abuse of dominance in the CMA, and yet the CMA could decide to do the same case under unfair contract trading terms, rules. The one does not preclude the other. So I personally was comfortable with this one.
Do you have a question from Lauro here as well?
From who?
Lauro?
Yeah, I'm just reading that one. Do I believe that discussions about abuse of dominance in the digital markets may affect investigations in non-digital markets? And lead to authorities to be more restrictive? Well, that's a loaded word. I don't necessarily know what you mean by restrictive in those circumstances. But what I would say is that I'm not saying that there should be or is a law of digital abuses. The way I would put it is that I think the Commission applies the law of Article 102 to digital markets. And if you take Google Shopping, for example, okay, they didn't do it as an essential facilities case. They said it's some kind of leveraging from one market into another market. Well, is that novel as a theory of harm or as a finding of abuse? Or will you not find in, I know it's sad what I'm about to do, but I think you'll find in case C311/84, Centre Belge Telemarketing, judgment 1985, that the Court of Justice says at the end, a dominant firm in one market who, without objective justification, leverages that dominance in order to reserve to itself a neighbouring market, thereby abuses a dominant position. Isn't that what Google did? And if you read the Google decision, you'll find there is a footnote referencing Centre Belge Telemarketing. So I think myself in Google Shopping, the Commission has taken established jurisprudence and has applied it in a digital world. Of course, recently we've had Google Shopping, Google Android, Google AdSense applying old principles to digital markets. It may be that our understanding of the law develops as a result of that, and then that law is not digital law, it's the law of abuse. And so those precedents in due course might be applied to pharmaceutical markets. So, I think we're talking about a single instrument and its ability to be applied to very different contexts. Then Franklin Gonzalez says, do I think competition authorities should really do these cases at all? Well, look, I hope and think I dealt with that in my presentation, where I said that there are very good reasons for competition authorities not doing excessive pricing cases. And I think if they find them, they can ask what other tools are available. It may be that the problem is government regulation. Well, then you tell the government to do something about it. It may be abusive behavior. It may be that there are unfair contract terms and conditions. It may be that there's a B2C regulation that can deal with it. It may be that there's B2B legislation that can deal with it. And I would prefer to use those other tools. But then I also did say one of my maxims of competition law is never say never. And I think that there are circumstances where you can have a fairly egregious case of excessive pricing. There's no other way of dealing with it. You've got a law that explicitly says an example of abuse is imposing unfair prices. Well, in those circumstances, is it really ridiculous for a competition authority to say, okay, there's no other way of dealing with this, we will pick it up and run with it? I think as long as the authority is being sensible, that it's a legitimate thing to do, I absolutely emphatically do not think that a competition authority should turn itself into a price regulator. That is insane. And I've always said that in my teaching, that you should beware becoming a price regulator. And when I once read an exam answer where the student said competition authorities are weary of being price regulators. I thought they really did not understand what I was saying. There's a difference between weary and wary. Okay, so that is that. Any other questions?
I don't think we have any other. I don't know if anyone wants to raise a question.
Oh, God, I realised we've just gone past 4:05. I beg your pardon.
Yeah, we've exceeded a little bit the time, but I don't see any.
And your cheese bread for lunch.
Yeah. So if no one has any further question, I would thank you all and let you know. Just remind you that next lecture is going to be on the 30th, next Wednesday, 10:30. So it's not on Thursday; it's going to be on Wednesday. And that's the last one where we're going to cover merger regulation and other issues. Professor, anything else? And thank you again for your lecture from today.
Okay, nice to see you all. See you next week.
Okay.
Bye.
Thank you all. Bye-bye.